If you work in a third sector organisation, then it's likely that you're dealing with some sort of personal data. And the way you need to handle this data is changing. The General Data Protection Regulation, or GDPR, comes into force on the 25th of May 2018, and it will affect all types of organisations. So there are things that you need to do to get ready. The Information Commissioner's Office, or ICO as it's known, is the data protection regulator. Their mission is to uphold information rights in the public interest, promoting openness by public bodies and data privacy for individuals. They have powers to investigate, and they can fine organisations for non-compliance. So we've put together some resources to help you become GDPR compliant. We have created web pages specifically to support the third sector with the changes ahead. Here you will find GDPR templates and webinars to help you. So why is GDPR happening? The GDPR replaces the EU's Data Protection Directive of 1995, which was introduced before the internet became the online business hub that it is today. GDPR will now enable EU citizens to have more control over their personal data and will provide a unified EU regulation. GDPR will replace the Data Protection Act 1998, but it is not a like-for-like legislation, and there are some key changes. GDPR applies to both controllers and processors. A data controller determines the purposes and means of processing personal data. A data processor is responsible for processing personal data on behalf of a controller. If you are a processor, the GDPR places specific legal obligations on you. For example, you are required to maintain records of personal data and processing activity. However, if you are a controller, you are not relieved of your obligations where a processor is involved. The GDPR places further obligations on you to ensure your contracts with processors comply with the GDPR. Personal data. The GDPR applies to personal data, meaning any information relating to an identifiable person who can be directly or indirectly identified in particular by reference to an identifier. Sensitive personal data. The GDPR refers to sensitive personal data as special categories of personal data. The special categories specifically include genetic data and biometric data where processed to uniquely identify an individual. There are 12 steps that you can take to become GDPR compliant. You should make sure that decision makers and key people in your organisation, such as the trustees and senior staff, are aware that the law is changing to the GDPR. They need to appreciate the impact this is likely to have and join you in the journey towards GDPR compliance. You should identify and document what personal data you hold, where it came from and who you share it with. If you are a large business, then you may need to organise an information audit. When you collect personal data, you have to give people certain information, such as who you are, how you are going to use their information, and who you are going to share it with, if anyone. This is usually done through a privacy notice. Your organisation is probably already using privacy notices, but under GDPR, there are some additional things you will have to tell people, such as: what is your lawful basis for processing their data? How long will the data be retained? That they have a right to complain to the ICO if they think there is a problem with the way you are handling their data. You should therefore make any necessary changes to your privacy notices in preparation for GDPR implementation. Remember, the information must be provided in concise, easy to understand and clear language. The GDPR enhances the rights that individuals have in relation to their personal data and provides the following rights: the right to be informed, the right of access, the right to rectification, the right to erasure, the right to restrict processing, the right to data portability, the right to object, rights in relation to automated decision-making and profiling. You should check your procedures to make sure they cover all the rights. Think about how you would react if someone asked you to delete their data. Current data protection law gives individuals the right to make a subject access request and ask you to give them access to the personal data you hold about them. GDPR makes some changes to the rules about subject access requests, giving individuals the right to ask you for confirmation that their data is being processed, access to their personal data, and other supplementary information. This largely corresponds to the information that should be provided in a privacy notice. You must provide the information free of charge and without delay, at the latest within a month of receiving the request. You can only charge for requests that are unfounded or excessive. If you refuse a request, you will have to tell them why and that they have the right to complain. Under GDPR, you must have a valid lawful basis in order to process personal data. You will need to identify the lawful basis for your processing activity, document it and explain it on your privacy notice. Many businesses will not have thought about their lawful basis for processing data. The lawful basis is largely the same as under the Data Protection Act, but you will need to document it to comply with the accountability requirements of GDPR. At least one of the following must apply whenever you process personal data. Consent. The individual is given clear consent for you to process their personal data for a specific purpose. Contract. The processing is necessary for a contract you have with the individual. Legal obligation. The processing is necessary for you to comply with the law. Vital interests. The processing is necessary to protect someone's life. Public task. The processing is necessary for you to perform a task in the public interest or for your official functions. Legitimate interests. The processing is necessary for your legitimate interests or the legitimate interests of a third party, unless there is a good reason to protect the individual's personal data which overrides those legitimate interests. You will need to decide whether you have to use consent as a lawful basis for processing personal data. Consent is only one of the possible lawful bases, and you should read the ICO guidance to find out whether this applies to the way you are processing data. If you do need to use consent, for example for marketing purposes, you will have to make sure that this consent is freely given, specific, informed, unambiguous. Under GDPR, consent cannot be inferred from silence, pre-tick boxes or inactivity. It must also be separate from other terms and conditions, and you will need to have simple ways for people to withdraw consent. Children need particular protection when you are collecting and processing their personal data, because they may be less aware of the risks involved. You should start thinking now about whether you need to put systems in place to verify individuals' ages and to obtain parental or guardian consent for any data processing activity. You will need to get consent from whoever holds parental responsibility for a child under 13, unless the online service you offer is a preventative or counselling service. You should write clear privacy notices for children so that they are able to understand what will happen to their personal data and what rights they have. A personal data breach is a breach of security that leads to the accidental or unlawful destruction, loss, alteration, unauthorised disclosure of, or access to, personal data. This includes breaches that are the result of both accidental and deliberate causes. The GDPR introduces a duty on all organisations to report certain types of personal data breach to the ICO. You must do this within 72 hours of becoming aware of the breach. If the breach is likely to result in a high risk of adversely affecting individuals' rights and freedoms, you must also inform those individuals without undue delay. Failure to report a breach to the ICO could result in a fine, as could the breach itself. Think about how you will make sure that you have the right procedures in place to detect, report, and investigate a personal data breach. The GDPR makes privacy by design a legal requirement under the term data protection by design and default. This means that you should build data protection into your projects from the beginning, rather than bolting it on as an afterthought. The GDPR also makes data protection impact assessments, or DPIAs, mandatory in some circumstances. DPIAs are a tool which can help organisations identify the most effective way to comply with their data protection obligations and meet individuals' expectations of privacy. You must carry out a DPIA when, using new technologies, and the processing is likely to result in a high risk to the rights and freedoms of individuals. If you were unsure whether you need to carry out a DPIA, check the ICO guidance on their website. The GDPR requires that organisations appoint a Data Protection Officer, DPO, in some circumstances. This will usually be the case if the organisation is a public authority, carries out large-scale, systematic monitoring of individuals, or large-scale processing of special categories of data. But any organisation can appoint a Data Protection Officer. Whether or not the GDPR obliges you to appoint a DPO, you must make sure your organisation has the staff and skills to meet your obligations under the GDPR. It is good practice to designate someone to take responsibility for data protection and decide where this role sits within your organisation's structure and governance arrangements. The absence of a DPO is not an acceptable excuse for failing to implement GDPR. The GDPR includes provisions that promote accountability and governance. The principles of accountability and transparency have always been implicit requirements of data protection law, and the GDPR elevates their significance. But under GDPR, you are required to demonstrate that you comply with the 6 data protection principles. The controller shall be responsible for and be able to demonstrate compliance with the principles. The measures you put into place should minimise the risk of data breaches and uphold the protection of personal data. For more information and guidance on GDPR, please visit www.wcva.org.uk and see our desktop data campaign.